getting into this business really was a fluke. And it was because of my own entrepreneurial journey. So, I'm a trained engineer, and engineers are typically kind of reclusive. They tend to be, kind of introverted, but very, very creative in a different sense. So I used to carry around a composition book, if any of you guys remember what a composition book looked like, right? And I would just jot down my ideas. I want to do this. I want to make smoke come out of a coffee cup sitting on a billboard, all this crazy sort of thing. But, I met uh, a gentleman who is still my partner to this day in some other, IP matters. But we used to sit on the board of the American Society of Mechanical Engineers here in Hartford. And I remember asking him a question one day. I said, man, I got these ideas. And he was a patent attorney. And I said, if I wanted to make money with this stuff, what would I do? And he kind of looks over at me with this wry smile on his face that he still has after almost 30 years. And he goes, Will, what's wrong with you? You license it, right? And I go, license it? What is that? Right? And so, a couple of years actually go by, and I'm still kind of jotting my ideas, but I'm working as an engineer in the aerospace industry, not really thinking much about licensing, about patents, about entrepreneurship. I just want to do my job and get my promotion and get to the next level. He calls me up 2 years later and he says, hey, you remember that conversation we had? We got a job that we're looking to fill down in Fairfield with a company called Competitive Technologies, right? And this company did licensing, they did commercialization work primarily for universities, but they were opening a new segment geared toward corporate clients, okay? And he says, we need someone to come in and work our corporate portfolio. And what that really meant was there were a lot of companies. IBM was our biggest client at the time. And there were Lucent and a few other clients that had patents that wasn't supporting a product that they were making. And typically they would just get rid of these patents, because you got to pay fees to keep them going. And they would get rid of these patents unless they found a home for it. Where our job was to sift through all of these patents and then find a home for these patents. And I approached it as a scientist, engineer, technologist. Wrong move.
Really?
Wrong move. In a sense, for the company that I was working for and what their niche was, it was the wrong move. It helped in one respect to understand what your product is. And I'm going to, probably backtrack later on in our discussion. But the real key to monetizing that paper asset was understanding what patents do. And what patents do is they give you a monopoly in a particular functional area, technology area that prevents other people from doing the same thing. So if you had, let's say, cell phones, and you were the first person to get a patent because you developed technology to put a camera on a cell phone, then what you've done is if your market thinks that's a great idea, and your patent prevents other people from selling into that arena, then you own 100% of that market. And once I understood it was what was written in those claims that was the value, I said, I got to learn this more. I got to do a little bit more. So I sat for the patent bar. And the fact that I told you that I'm an engineer, whatever, is because only scientists, engineers, people with technical backgrounds can actually sit for the patent bar. So if you're a political scientist and you got a law degree or whatever, sorry, doesn't matter. You have to have that science or technical background in order to sit for that bar.
Interesting.
And I did, and I passed the bar. And because I'm not a lawyer, meaning I didn't go to law school, I'm still registered with the USPTO as a licensed patent agent. Now I do a whole lot of other stuff in my firm as I grew my own entrepreneurial journey, but that's kind of where it started. So if I could say anything else, that's kind of like the introduction to kind of who I am, but why I do what I do is because I realize that the people in what I call my community don't necessarily have that knowledge or have access to understanding how these assets, and I'm not just talking patents now, talking patents, trademarks, copyrights, trade secrets. We don't understand how we use these assets to support and further monetize our businesses. So there you have it.
That is
This is
fascinating.
oh,
I
uh-huh.
didn't realize that a person could sit for the bar but not necessarily be uh, an attorney. That's
A lawyer.
a lawyer,
Yeah.
right? That's great. Wow, good. I learned
It
something
is
new
the
today.
yeah,
Seriously.
it's the only area that I'm aware of where you could do that. And prior to oh the 19 mid 1970s or something like that, if you did sit for the patent bar and you passed the patent bar, regardless of whether or not you went to law school, you were called a patent attorney.
Hmm.
Of course, attorneys don't like that. So,
Right. Yeah.
I,
so
I can
yeah, so
imagine.
they changed that, but probably for good reason because working in a court, and so I think it's important for the audience to understand
Mm,
that working inside of a courtroom is very different than working inside of the USPTO, which also has its own tribunals and courts, but judges were probably pulling their hair out because you had folks who never went to law school
mm.
trying to move or argue cases in which they just really didn't understand the basic law. They understood patent law, but they didn't understand law in general. So they made the split, and folks like us typically wind up at firms supporting other lawyers. And I decided to take a different path to kind of hang my own shingle and expand my business because of the people who I wanted to serve. And that's where Emanus comes from.
I
So it's
love.
interesting. I was going to
Mhm.
say it's interesting because I was going to my one of my questions that I had was so in 1999, that's when you formed Emanus and you
Mhm.
brought together other colleagues to form your company, your firm. And
Yep.
so I was wanting to know what was it that really informed you that this was a lane that was needed in the community? Had you had different experiences with other entrepreneurs where they were creating and not protecting? What was it for you that really said, I need to put together this firm to help the people in the community?
It started with, believe me, when these other colleagues that you talk about, when we formed Emanus way back then, it wasn't as a legal services or patenting services or IP services firm. That happened later on. Uh, it was formed because of my being at Competitive Technologies. I realized something. Lawyers have a way of speaking to each other. Okay. They also have a way of sometimes speaking to the general public. And I was one of those people, and I thought I was a pretty smart cat, right? And I'm like, what in the world are they talking about? Right? What are they talking about? And then when I did my investigation, I said, oh my gosh, you could make it much simpler for people to understand what IP, what intellectual property really means, and I'll use the pejorative term dumbing it down a little bit, but getting to the simplicity of what it is that they're using this asset to do. And so Emanus was created to be a news service, and it was supposed to take big cases and take IP matters and all this sort of thing and kind of roll it up and feed it back out to the general population, to enable them to understand, oh, I just sat in this guy's office and he did a patent for me, but I really don't know what it is I have. So let me tell you what it is that you really have. And then once you know what you got, then you can kind of make decisions as to how you should use it. So that's how it was formed. But once I, got registered, I kind of went in and out of corporate jobs. I have a pretty eclectic background: insurance, manufacturing, sales. I've done it all. And not until now do I realize that it really helped to have that kind of a rounded background. But once I passed the bar back in 2000, really it was much later, maybe 2008, someplace in that neighborhood, I said, well, I could do these big deals that I was working on, continue to do that, or I can have what I call transactional money. And transactional money is I can file, draft your patents. I can help you connect you with folks for trademarks. I can do all this stuff for copyrights. And I could sit as an advisor, in between my clientele and sometimes the firms that they were talking to, so that they understood what it was they were buying. Today, however, I bring those services under my own roof in-house so that I can provide all of those services directly.
I love that. So the simplicity that you talk about is so
Mhm.
vital to entrepreneurs, especially those who are starting out in the very early stages. And I heard you say
Mhm.
copyright and things like that. And I know that there's a lot of confusion around copyright, both the copyright in terms of the protection plus the person who's copywriting, knowing the difference,
Mhm.
but
Mhm.
also, patents and things like that. Can you, in layman's terms, could you explain to the listeners the difference and what they should be thinking about as they start their entrepreneurial journey?
Yeah, and actually, that's a great question because I get phone calls all the time where people go, "I want to patent that. I want to patent that," but they don't understand, that it is not a patent that you seek. It's probably a trademark that you seek. Or they go, "Hey, I got this thing and I want to trademark it," and I go, "No, actually, that's a copyright that you're looking for and not a trademark." So, in very simple language, patents, and there are different types of patents. We won't go into all of the different types, but a patent protects, right? Provides you a monopoly, even if it's a thin piece monopoly. Like I said, maybe not the whole phone, but the phone with the camera, it will protect. And of course, technology continues to advance. So patents protect how things work and what they are, how they function, technical technology. That's what patents are meant to do. It's like if I'm the first person that invented a bicycle, and in layman's term, a frame with two wheels, a brake, a seat, a handlebar, and I was the first person to invent that, and I'm going to call that a bicycle. But as far as the patent world, it has a function, right? Gets you from A to B by pedaling. But the word bicycle itself, who cares? That's what they called it, but it doesn't have anything to do with what it is per se. But bicycle, if it's the first time that that term was used, right? Uh, we won't go into the nuances, but if it's the first time that term is used, it could have been a trademark because people didn't understand, prior to its coming into the market, so what do I where do I get this thing? What do I call this thing? Now you can't do that today, of course, because your trademark can't be descriptive. But the point is, what you call it is its brand. It's how people remember that product or that service, that they want to purchase. And the reason, and trademarks operate very differently from patents because you can have trademarks selling exactly the same item, right?
Hmm.
I mean, they could be selling a comb, right? And maybe the combs have different designs, blah, blah, blah. But, I'm going to call my comb an Afro pick,
Hmm.
and I'm going to call my comb a styling comb, right? Again, as long as it's not too descriptive of what that item does, people are able to distinguish between not only the type of comb or the type of product that they're looking for, but also in some measure where it comes from. A better example might be this. I have, what was that? There were a couple of bicycle brands out there.
Mm,
Kind of
Hmm.
help me out.
like
I'm drawing.
Peloton, like those kind of bikes.
Oh, okay,
Exercise
good.
bike?
Yeah, let's do that one. Okay. All right. So, from a patenting point of view, it has a function. It has a weighted wheel. You pedal because the weighted wheel kind of transfers some energy, right? It has a function to make you burn calories. But there are many types of them out there. But you may have a company that takes its own exercise bike and they call it Peloton. And they've done some other things to their bike to distinguish it from somebody else like Kaiser, who makes a bike as well. So Kaiser's, kind of in, and their name and what their customers understand them to be is this is German engineering. We don't use pads that touch the steel wheel. We use magnets. And the closer the magnet gets to the wheel, the more energy it takes to push the wheel, or the further away it gets, the easier it is to do the wheel. Whereas Peloton, their bike may still have physical brakes, and the harder you squeeze the brake, the more energy it takes to move that thing, or the lighter the brake squeezes, right? Then it takes less energy. They're both bikes, they're both doing the same function. But if someone wants a bike with the brake versus the bike with the magnet, they're going to choose Peloton, just to use them as an example,
Mm,
versus Kaiser, right?
right.
It's almost like Del Monte.
Mm.
I think I told you this story. There, look at brands and how people think about and remember brands. And brands really embody a lot. Sometimes they embody quality. Sometimes they embody a certain taste, like RC Cola versus Pepsi Cola,
Mhm.
right? They're both colas. You're not going to get a patent per se on that formulation anymore. But there's certain things that can be done to it that gives it a certain uniqueness. And it is because of that uniqueness that a certain part of the market wants that RC Cola versus the Pepsi Cola versus Coca Cola, right? My mom always said, "Hey, that one is too sweet. Don't bring that one. If I put it on the grocery list, whatever you do not bring Pepsi Cola into my
Mhm.
into my house." My grandmother was like, "Do not bring anything other than Del Monte peas for my Thanksgiving dinner." Okay.
Mhm.
Because if it was anything other than Del Monte, she would send you back to the store to get that brand. People recognize brands, and that's what trademarks do. Now, let's move to the next category: copyrights. What are copyrights? It's really an expression, a tangible expression, something you can touch and feel, of your own intellectual property, right? Your own creativity. It could be a song, it could be a novel, right? It could be a piece of sculpture. For that matter, it could be software code, it could be your website code. All of these things are protected under copyright law, which, by the way, is not a part of the United States Patent and Trademark Office. Those are actually handled by the Library of Congress. But it is still another form of intellectual property protection. So, to sum it up, patents function, trademarks brand. Where do I get it? What does it stand for? And who sells it? Nike versus Adidas. And then lastly, copyrights, like that little snippet that Robin Thicke in his group
Yeah.
kind of usurped from the Marvin Gaye Foundation.
Yeah.
By the way, that was about a $7 million mistake.
Mm-mm-mm.
Wow.
Yeah,
Pennies, pennies.
Yeah,
pennies, pennies.
of course.
But good question. They're different,
Yeah.
and they all are meant to help you in different ways.
So it sounds like, obviously, from what you're saying, thinking about patents and copyright, trademark, it's should
Hmm.
be a part of your strategic plan when you're starting business. So let's say there's
Hmm.
someone who is creating courses and they have their unique spin on something. They should be thinking
Hmm.
about copyright, probably.
Absolutely,
Yeah.
absolutely. They're covered. Those would absolutely be covered under copyright.
Hmm.
Okay.
So I
Now, the type, go ahead, I'm
oh
sorry.
no, go for it. Go for it.
No, I'm saying the contents, right,
Mhm.
is covered under copyright, but sometimes your own intellectual property or your own creation, can be covered under various, types of IP. You tend to find this uh, sliding back and forth in the trademark and in the copyright world mostly. You will not typically find that in the patent world because, again, actually, it's frowned upon to use trademarks or registered trademarks or any kind of trademark when you're filing a patent, because what they're concerned about is what is it and how does that technology work. But you will find these things start to creep in the trademark and in the copyright world.
Interesting.
Wow.
Mhm,
So, if we are thinking about an entrepreneur that is new in
mhm,
their journey and they are really ready to hit the ground running,
mhm,
but they're also realizing that they have content out there that is
mhm,
valuable to their brand.
mhm,
At
mhm,
what point would you recommend that someone new in their journey, begin to have that kind of that conversation about what should and should not be protected, especially if you're dealing with someone who has
mhm,
their capital,
mhm.
it's on the lower end. Are there any workarounds, or at what point should they really consider, speaking to someone to help them through this process?
I always say the sooner the better. As soon as the idea hits your head and you've kind of convinced yourself that this is a road that you're going to pursue or go down, then you want to talk to someone like myself to, kind of get a sense of what it is that you don't know. And I'll give you an example. People will spend money on websites. They will spend, and those websites are very particular because typically it tends to include the name of the business that it is that they want to trademark. Okay. Now it operates on two different fronts, on two different platforms. You can go get the URL, but just because you're able to secure that URL does not mean you're going to be able to get that trademark. And so here's what happens. They will spend this money, they will buy collateral, they will make brochures, they will, put awnings out in front of their business, whatever the case may be. And then they go, oh, maybe I should trademark that, right?
Mm.
And when you do that search, that trademark search, and if you're not looking for it, it typically won't reveal itself to you. But once you start looking for it, then you realize that, oh my gosh, I am blocked from being able to use that trademark because someone else that you're not even aware of is registered that trademark
Mm.
or prior to you. Now, it only really matters, and again, without getting too deep into details, if it's in your goods and services class, right? And so someone can have two similar names, Danya, to use as an example. They can have similar names, but the product categories are so far apart that there won't be a refusal or necessarily an opposition to you getting that trademark registered. But again, you're kind of playing Russian roulette in that particular case because until you do that search in the beginning, it kind of tells you, I might need to change my strategy. I may not want to put this logo or this kind of figurative mark on my product because as soon as it hits the street, then the real owner has the ability to literally knock on your door. As you would know, Amine, you could shut them down.
Yes.
So your investment, your investor's money, has kind of been wasted because now you have to backpedal and rebrand, and that can be costly. So the simple answer is as soon as you think you're ready to actually pursue, a business venture, and particularly for trademarks, you want to talk to somebody early on before you start investing in your websites, your marketing collateral, and even just how you message yourself to people.
Mm.
Mm,
Okay.
it's really
Oh,
good.
That
that's the general rule,
Yeah,
right?
yeah.
that was jam packed.
Yeah, yeah. But sometimes we get lucky, right? Because let's say you're early stage and you're a technology company. Okay. Let's just say you're a technology company. We've developed a new process for making plastics that don't break down into microplastics and get into your body, right? There's a problem and they have a solution and they have a technology for providing that solution. They're going to file for a patent, assuming, again, even patents have to be novel. It can't be already disclosed in the public domain. In other words, people come to me and they say, hey, this thing is no longer patented, can I patent it? And I go, no, it belongs to the public now. And so you can't repatent something just because it came off of patent, because that idea has already been given to folks. But to get back to my point, so this young technology company needs to be able to communicate, with people. And so it may come a point at which the brand that they're using to communicate to grant offices or to investors, prior to the real investment coming in, there won't be a problem for them to rebrand once the investment dollars come in. For those kind of people, I typically say, unless you're treading on someone else's turf, uh, you know, my colleagues might, hang me for this one, but that's when you kind of use the TM, right? I wouldn't spend the money personally to brand that, because it really isn't going to become a brand. You kind of know that as you're looking at your business, your technology development, that someday I might actually license it to GM or to Abbott. And you're not there, they don't care about your trademark. They have their own trademarks, right? And they will sell, if they license it, they'll sell it, in a channel and under a name that they want. So you're just using it as a way to communicate with people so that they know who you are as an early stage company, but you don't necessarily need to register that, because it's going to go away and it's going to go away.
So, real quick, you did mention licensing. For
Mhm,
our entrepreneurs that are listening that are not really familiar with this, can
mhm.
you kind of describe what you mean by licensing?
Okay, here is licensing in a nutshell. Uh, Think of it as a house, okay? A patent is a house. It's a type of a house. It's a certain type of intellectual property protection, but you have built this house and you have been issued a patent. A trademark is also a house, just a different, maybe it's a condo, but it's a different kind of house. You've built this house and you've sold product and you've established a clientele of people who recognize and understand that brand, and they know what they're getting when they see that brand. And then a copyright, hence I'll go back to the example of songs, music, books that somehow become movies, right? But if it's books that could become movies, just hold that thought. Now, these houses, you can rent them, right? You don't have to practice yourself all the time. You can rent them. So your patent, you said, hey, look, we don't have the wherewithal, the channel, we don't have what it takes to actually sell a product that would be protected by that patent. So we're going to go out into the marketplace and find people who are in that space who think that our technology or our patent is valuable, right? And the reason they're going to think it's valuable is for the same reason you went down that road in the beginning. And that is, it keeps other people from selling that same particular item that's protected by that patent. Okay. So we call that renting licensing. So they'll come to you and say, yeah, we will give you a royalty. We will license your patent, from you. Or in some cases, larger companies, they just buy you out, right? They just buy the patent. But that's licensing for a patent. It works the same way with trademarks. Once you've established a trademark that people recognize and other people say want to sell a similar product, you know, using your trademark. Again, there's stipulations around quality, around how much you can sell, all that sort of thing. Typically, it's quality, but you can license them that trademark, okay, in order to sell that item. And a copyright is exactly the same thing. Let's say you wrote a novel and someone wants to rent or license that novel. Why? For the purpose of making a movie, because it's based on your copywritten material. But it's just your way of saying I'm going to extend my market, extend my ability to make money by allowing other people to use my intellectual property. And the quid pro quo is you can use it, but you're going to have to license it from me or pay me rent for the amount of money that you're making or whatever negotiated deal we can come to. That's what you're doing. A lot of my inventors have that as a goal when they come to me, for their patents. And it can be a slippery slope sometimes, because you're sitting back and you're trying to assess whether or not this thing that you just came up with is really going to be of value to someone else.
When you were talking about that just now, I'm thinking about
Mhm.
just kind of browsing through social media, and oftentimes you find creators, and I would assume they are in business, and they
Mhm.
will reshare other people's content. Now, in the
Mhm.
assumption that that content is copyrighted, is that entrepreneur able to monetize what they do in business in that way?
It is a legal matter, and so take my comments with regard to that, with the disclaimer that this is not legal advice but
Right.
professional advice. But think about it this way: it's actually a good question. So let's say you created some harmony, uh, hustle podcast,
Hmm.
right? And that material, if you've copywritten it, right, it's already copywritten, by the way. Okay. It's just not registered. And it's just an easier path to monetizing if people, usurp or take it if it's registered. So, with that said, you've created all of this copywritten material, and someone else takes your material and they start distributing it elsewhere. So, there's a fine line between sharing
Hmm.
and distributing.
I see.
Okay. And it typically it because sometimes the money is not transparent when we talk about distributing on these platforms, but they're making money with your content. That is a copyright violation.
Okay. Yeah.
Okay. But as a casual user, if I'm just sitting here and I'm kind of looking at your content and I go, oh, this is great. And you just share it, with someone with no intent to monetize that sharing, then that is not a copyright infringement.
I see.
Okay. So the big example, and there are some cases, but there are many cases actually floating around where people have finally kind of been fed up with this, are the talking heads, right? The talking
Yeah.
heads, and you see them in the little corner, but none of the content that they are distributing. Okay. They're trying to build their own channel. That's called monetization. But the content that is being distributed is your, Harmony Hustle podcast. And they're not paying you one dime for that. Okay. Now they should. And it's nothing wrong with them doing that if you have a deal worked out, some sort of a licensing deal for them to distribute your content to make money. It's like they make $1, they give you 25 cents, right?
Hmm.
But a lot of our distributors are just pulling the content without an agreement, to actually distribute that from the actual copyright owners, meaning you.
Mm.
In the same vein of this,
Hmm.
when we think about entrepreneurs, oftentimes it's very common for an entrepreneur to work with, a company like Uplift, Fiverr in terms of,
Hmm.
you know,
Hmm.
creating, logos and digital material and covers and things of that nature,
Hmm.
who actually owns?
Well, it's a great question. In the absence of an agreement that says otherwise, then the creator owns it. So there is nothing wrong with using those services as long as upfront you establish what we would call a work for hire agreement. You can have people code for you. So you can have people actually sit in your company, right, and create patents or technologies that ultimately become patented. In the United States, they have to be listed on that patent as the inventor. And in the absence of any other agreement, the inventor typically is the owner. However, when you're working for companies, if you read your employment agreement,
Yeah.
right?
Fine print.
Fine,
Yeah,
fine print.
you will realize that you are inventing. That's your job. You're inventing on behalf of the company. And so that employment agreement and other agreements will actually list the company as being the owner. It is the same with you working with a Fiverr or working with some other contractor who is creating something on your behalf. They may be the creator, but you will have them sign an agreement that says that all of the content that they did create, you own it.
So, what happens if an entrepreneur went through one of these companies and work was created? They did not have that agreement. Is there something that can be done afterwards, after the fact that it has been created, distributed?
The
Mm.
gut and yeah. Well, we live in
This
a
is real,
society where
right?
and we live in a society where you can sue anybody for anything, right?
Right.
The question is, the bounds, or the strength that we're given with registering, patents, trademarks, copyrights, is that it has a predominance, in the courts because you've done your part to try to protect your intellectual property. Okay. In a case where you just freely just worked with somebody with no agreement in place, and then you come back later on and you go, wow, that's what I was doing. Well, you kind of almost gave it away. You
Hmm.
can sue them, but I believe, again, my professional opinion is that it will be difficult for you to stop them in that particular case because you did not have an agreement, stating that they were work for hire or creators for hire.
And I was more so coming from the perspective of the entrepreneur where they went to a Fiverr for a logo creation and then
Mhm.
learned later on, years afterwards, that they should have had a contract for them to own it outright. And that has not happened.
Mhm.
Would they go back to, or just leave it as it is, go through with applying for, an IP or protecting it and hope for the best?
Well, if you can prove that that the copywritten material was yours prior to that disclosure, then yeah,
Hmm.
yeah, you could go ahead and show that proof and register that copyright. You may even be able to show proof of a trademark and then register the trademark, but it won't be done without potentially without a fight. That's what you should expect. And with the fight, it means that then my other colleagues and friends get involved, and it for young early stage entrepreneurs with very limited budgets, it's kind of like the death knell. It's like, do I continue to put my money into my business, right, and try to grow my business, or do I put my money into these other places to try to fight for something that is going to be long, drawn out, and very costly, and so I never get to my dream. Uh, I always want folks to understand that when they come to me with the dream, whether it be copyrights, trademarks, or patents, that the business is the business. Patents, copyrights, trademarks aren't your business. They protect your business. And what I mean by protect is they keep people from encroaching on your good hard work. And the only reason they would do that is because they realize your hard work has built that brand, and people go, oh yeah, I heard about that. Let me go in that shop. I mean, we're talking about to the tune of billions of dollars of counterfeit product, even that enters into our borders, with the trademarks and, all the other quote unquote looks of your IP that you're never paid for because they're taking advantage of what you've already built. So always remember your the patent isn't your business, the business is the business. The trademark isn't your business is your business. So spend your money in your business and then wisely spend your money on protection. Unfortunately, in this environment, particularly when it comes to patents, you almost need to have some level of spend early in order to provide some protection around disclosure. So for technology, we do things like we call provisional patents. The way I do them, they're still, full blown documents. Okay. And there are legal reasons for doing that, but they tend to be less expensive than going for, say, a full patent, right? But you need that because you want to talk to investors, you want to talk to a potential client, and there's certain things you have to disclose to them in order, to make that deal, the business happens. Now, the risk is they may want to take that from you. But if you have that patent filed that ultimately issues, then you have them, right? That's kind of like willful infringement. And most companies don't really want to do that, which is why they ask you, if you have patents filed before they will even talk to you. A lot of them don't even want to sign NDAs because, it's just a legal mumble jumble, right? It's
Yeah.
kind of like, oh my gosh, I'm going to wind up in court arguing with this person over this idea that they thought they brought to us, but we actually already had it. And so now you're in court fighting over that rather than spending your time, on the business. But if you've done your proper due diligence and you file for the patent, it gives you a little more comfort to then go and have that conversation. Trademarking is a little bit different. Like I said, you may need to rebrand. You may not want to brand too early. Okay. But you're given a little more leeway in terms of registering that trademark than you are with, say, patents. Copyrights kind of happen at the moment of expression, at the moment that you make the recording, at the moment that you launch the website. It is already there. Again, if you want to extract value from that, then you want to make sure you register because it's easier to get your money or to issue a cease and desist once you have that registration in hand.
So one last
Yeah.
Wow.
one last question for you. So you have for the
Yeah.
brand new entrepreneur, someone who has the hobby, passion, whatever it
Mhm.
happens to be, if you could advise them, not in a legal way, on like
Mhm.
one or two things that
It depends if it's
okay.
patents. I can give them that advice. But go ahead.
But what
Yeah.
are your top one or two recommendations that they need to take in the very beginning of their process?
Understand, and I don't want to end this on a negative, but understand that if you build it, they won't come.
Mm.
If you build it, they won't come. If you sell it, then they will come. So that's just a funny way of saying this. You have this thing, this burning desire. You want to, create this new item. You want to sell this new item. Even I want to make this song. I would try to find my first customer. I would want to validate first that it is something that I can actually sell, rather than my emphasis being on, can I protect it, or going to this full blown out thicket of protection documents. I want to find out if I can actually sell this thing, or will people actually buy this? And that is, I think, the difference between the good entrepreneurs and the ones who just have this dream. It is, and I like to use you as an example, Amini. I have this tool, but you tested this tool. You had people in a controlled environment, and you knew based on that interaction that, yeah, this is something that is worth spending the money to protect, because this is something that people would want, right? And so if I can give them that last kind of thing to keep in mind, yeah, talk with people like me early on just to kind of flesh out your check boxes, but make sure that your business is really going to be a business before you start spending a lot of money, on IP protection.
Wow. Well, as always, we appreciate you. Thank you
Yes.
for taking the time just to pour into us, our community.
Mm.
I've had the pleasure of working with you for many years now, and I have to say, you have been a great resource. And I thank you for just sharing your knowledge. And for anyone that is watching, if you are in the beginning stages of your business and you are looking for protection, reach out to Will. He and his team will make sure that you are led down the right path.
Yeah. I would, even my own self-serving commercial is
Yes.
that it doesn't cost you anything to schedule an appointment with me. I'm free and open on the internet. You schedule an appointment, 30, 45 minutes. Believe me, I think it would be well worth your time to just have that no cost conversation, just to make sure this is, a direction that you want to go in, and if it makes sense for you. So I would end with that.
Awesome. Now, can you
Yeah.
please share with the community how they can get in contact with you?
Yes, very easy. You would go to www.emanus.com. That's spelled E, M as in Mary, A as in Apple, N as in Nancy, U is in underscore, S as in Sam, dot com. And right at the beginning of my website, which will explain my services, but also there is a schedule time with Will. Click on it. My calendar is open to the public. You find a free spot, feel free to go ahead and schedule, a time with me. And because, as you know, Amini, I tend to work deep into the night sometimes. If it's after 6 p.m. and you're working and you still need to have a conversation, then my phone number is there. Text me or give me a call, and we can always make other arrangements to connect.
Perfect. Thank you so much, Will.
Yeah.